Good afternoon and welcome to the second Taylor Wessing Contentious Trust and Estate webinar, during which we will discuss both the development of foundations as a vehicle for managing assets and the challenges which may be brought against foundations. By way of introduction, my name is Kate Silverman and I'm a Senior Associate in the Contentious Trust and Estate team here at Taylor Wessing. My co-presenter today is Amelia Pishkos, another associate in our team. As usual, you can put any questions that you may have during the course of the webinar to us by simply typing them into the panel below the slides on your screen, and we will deal with as many questions as possible at the end of the talk. Firstly, we wanted to give a brief overview of what a foundation is and how foundations have developed over recent years. Foundations originated from civil legal systems, where there's a long history of performing charitable, investment and estate planning functions. They're therefore similar to trusts in terms of their purpose, but trusts can be differentiated on the basis that they distinguish between the legal and beneficial ownership of assets, and they impose fiduciary duties on the trustees, with those duties being owed to the beneficiaries of the trust. Civil legal systems do not recognise this type of division of ownership and require that one entity has full ownership of assets. A foundation, consequently, has its own legal personality, with all assets held by it absolutely. Now, that being said, a foundation can be established to enable the donor of the assets to dictate that the assets are to be applied for a specific purpose, and the assets may then only be used for achieving that purpose. Foundations, therefore, can still be used to achieve the segregation of assets from the original donor's estate, while still being utilised according to the donor's wishes. Now, the establishment of private foundations in offshore common law jurisdictions is a relatively recent development. Foundations in such jurisdictions share a number of the characteristics of civil law foundations, but they're generally governed by local legislation. So, by way of example, the St. Kitts Foundation Act was established in 2003. That was followed in the Bahamas with the Foundation Act 2004, whilst Jersey more recently enacted the Foundations Jersey Law 2009, with a similar law following in Guernsey in 2012.
Although each jurisdiction may have slightly different rules on foundations, as prescribed by the relevant legislation, generally, offshore foundations are very similar in their makeup. A foundation is a legal entity incorporated and registered under the relevant local law. The founder of the foundation will transfer assets to the foundation, and those assets then belong to the foundation both legally and beneficially. The foundation manages those assets in accordance with the object or purpose which is specified in the foundation's charter. The charter essentially sets out the basic details of the foundation, including the foundation's name, the name and address of the founder, the purpose or object of the foundation, a list of the initial assets of the foundation, and a statement setting out the period of time for which the foundation has been formed. The foundation may also have a set of articles, regulations or bylaws which provide further governance of the foundation, including details as to how the assets of the foundation are to be distributed, the identity of any beneficiaries of the foundation, and the regulation of any governing body of the foundation. There is generally a foundation council which is made up of natural or other legal persons, and its general role is to ensure that the foundation complies with the provisions of its charter, any articles, and the relevant legislation. Its specific role will be set out in the relevant legislation, regulations, and or the foundation's charter or articles. The specific rules governing foundations will obviously depend upon the relevant jurisdiction and legislation, and we will explore the legislation relating to foundations in a few jurisdictions later on in this presentation.
A foundation can essentially be seen as a hybrid between a company and a trust, combining certain asset protection elements of each vehicle. There's a number of similarities between trusts and foundations. The principal ones being that assets can be transferred or donated to both vehicles, both can be revocable, both can be created during the founder or settlor's lifetime or on their death, both can be unlimited in their duration, both provide for the appointment of a protector or an enforcer. And also with a foundation, one can have the founder as a member of the council, and they can then exercise control over the assets of the foundation. In a similar way, the settlor of a trust can retain certain powers, such as to direct investments. There are, however, also some notable differences between a trust and a foundation. So by way of example, a foundation has, as I said earlier, an independent legal identity and holds assets in its own name, whereas a trust does not have a separate legal identity from its trustees. Trustees will contract personally in their own name, whereas the council members of a foundation will contract in the name of the foundation. Members of the foundation's council act on behalf of the foundation and do not assume personal obligations, which is unlike trustees. A foundation's charter is a public document, although the articles of a foundation can remain private, whereas with a trust, all documentation relating to the trust will be confidential and will remain private. Now, changing the jurisdiction of a trust is relatively straightforward, but with a foundation, it would need to be re-domiciled, so that adds an element of complication. The powers of a foundation's council are generally more limited than those of a trustee, who, certainly in the case of a discretionary trust, potentially has unlimited capacity, subject obviously to the overriding requirements to always act in the best interests of the beneficiaries. A foundation also does not require an owner, so there's no need for succession planning. Now, there's various reasons why a client might use a foundation over a trust in relation to their wealth and asset structuring. A client may simply have a preference based on prior experience with foundations, particularly if they originate from civil law jurisdiction, as the concept of a foundation may be just a bit more familiar to them. Conversely, a client may have had a bad experience with a trust or with a set of particular trustees, and therefore simply wants to try something a bit different. Alternatively, a client may wish to maintain more control over the administration of their assets, and with a foundation, they can ensure that a family member or a close advisor is appointed as an officer of the foundation, and thereby has some direct control over the management of the foundation. Another somewhat emerging factor is a client's reputational considerations, given the recent negative associations in the press in relation to offshore trusts on the back of the Panama disclosure.
We thought it would be helpful to provide a bit more detail on the law surrounding foundations in Jersey and the Bahamas, as these are jurisdictions we regularly encounter. First, we turn to Jersey. Jersey foundations are relatively new legal entities, with the relevant law being established in 2009 in the form of the Foundations Jersey Law. The first point to note when establishing a foundation in Jersey is that there is no requirement under local law for there to be any initial endowment of assets. So a foundation can be established without holding any assets. This is obviously different to trusts, where one of the requirements to establish a trust is the need for certainty of subject matter. So what rights do beneficiaries of a foundation have? Pursuant to Section 25 of the Foundations Act, a person who is designated as a beneficiary of a foundation has no interest in the foundation's assets. A beneficiary may become entitled to some benefit at some point in the future as a result of the foundation's regulations or a decision being taken by the foundation council, but it is only then that a beneficiary has any form of claim in relation to that benefit. In such a circumstance, a beneficiary has no form of proprietary right over any assets, but rather the beneficiary will have a claim in debt or a right to specific performance. Under Section 25(2) of the Act, a beneficiary who has become entitled to a foundation's assets may then seek an order from the court ordering the foundation to provide the beneficiary with the appropriate benefit. The position is therefore similar to a company shareholder seeking the payment of a dividend. In such a scenario, the shareholder's right to specific performance only arises after a valid resolution of the company has been passed. The duties owed to a beneficiary are set out in Article 25(1)(b), which states that the beneficiary of a foundation is not owed by the foundation or by a person appointed under the regulations of the foundation a duty that is a fiduciary duty or is analogous to a fiduciary duty. The duties of the officers of the foundation are owed to the foundation itself in the same way that the directors of a company owe their duty to the company and not the shareholders. This is a key point which we'll be going on to discuss in more detail in the latter half of this presentation. Disclosure obligations in relation to beneficiaries are set out in Article 26. This states that unless the Foundation's constitution stipulates otherwise, there is no general requirement for the Foundation to provide a beneficiary with any information. Turning to issues of administration, generally a Foundation will be governed by the terms of its regulations, but local law does make certain mandatory provisions, including the following points. There is an obligation that the Foundation has a council to administer its assets and carry out its objects. The function of the council must be set out in the Foundation's regulations, together with any rules as to whether those functions can be delegated. The regulations will also govern the appointment, retirement, removal and remuneration of council members and set out how decisions of the council are to be made. A council must include a qualified person. This is a person who is registered under the Financial Services Jersey Law 1998 to carry on the trust business. What this means is that a qualified person will have a certain level of experience and knowledge recognised in the industry. The next most important person in a foundation is a guardian. A guardian has a general obligation to ensure that the council is carrying out its functions. The guardian also has the power to require the council to account to it, and, unless otherwise specified by the regulation, the guardian may sanction a decision or action taken by the council, even if that action would not have been otherwise allowed under the Foundation's charter, provided that the guardian is satisfied that it is in the best interest of the Foundation and that the council is acting in good faith. This sanctioning provides defence to a later claim relating to the relevant decision or action. The guardian in effect provides a second layer of supervision. The founder may appoint themselves or the qualified person as the guardian of the Foundation or as a member of the council, or in fact as both, but no other person may hold two positions simultaneously. The founder may also retain powers for himself to whatever extent he wishes to. As mentioned earlier, it is this that allows the founder to retain a significant amount of control over the administration of the Foundation, which makes it an attractive vehicle.
However, these elements of flexibility and control, which Amelia just outlined, are offset by the broad supervisory powers of the court, which can be initiated by a person with standing pursuant to Article 43(1) of the Act. Now, the definition of such a person includes the Foundation, the founder of the Foundation, a person other than the founder who has endowed assets to the Foundation, any assignee of a person appointed under the regulations of the Foundation, a beneficiary of the Foundation, a creditor of the Foundation, and in relation to any specific purpose, anyone who the court considers can speak to that purpose, and the Attorney General. So as you can see, this is a very broad pool of potential applicants. Now, in terms of the Jersey Court's powers, the court has the power to order compliance by a person who's failed to comply with the Foundation's law, or the relevant Foundation's charter or regulations. And this includes the power to order the Foundation itself to comply with its own charter. The court can also propose amendments to a Foundation's charter or regulations if it considers that it would assist the Foundation in administering its assets or attaining its objects. The court can also give directions to the Foundation, and Article 46(2) sets out a list of specific matters upon which direction may be given by the court. Now, this includes the meaning or effect of a term in the charter or regulations, the manner in which the council is required to carry out the administration of the Foundation's assets or carrying out its objects, the function of the council or any of its members, the function of anyone else appointed under the regulations, whether a person is a beneficiary and the rights of any beneficiary, and any other matter which the court considers relevant to the Foundation. The Foundation law in Jersey goes further in Articles 47 to 49 and sets out specific powers of the court, which includes the power to appoint a person to protect the interest of the beneficiary who cannot act on their own, to remove and to appoint a qualified member, to comply with a requirement or obligation on behalf of the person who has failed to do so, and to appoint or remove a person appointed under the regulations and on such terms as the court sees fit. We'll look at these court and statutory powers in more detail shortly when we look at the challenges which can be brought against the Foundation.
Turning next to the Bahamas. The relevant act in the Bahamas is the Foundations Act 2004, which was subsequently amended in 2007. To establish a foundation in the Bahamas, one requires a charter, the registration of the foundation, and a certificate of registration to have been issued. The charter itself will contain all the key details, including the purpose and objects of the foundation. An officer of a Bahamian foundation may be a natural or legal person. In the absence of a council, the officers will govern the operation of the foundation. The officers must exercise reasonable care and skill in conducting the affairs of the foundation, including in relation to the management and investment of the assets. Officers must also act in accordance with the charters and articles. It should be noted that officers can be held personally liable for gross negligence, willful default, misconduct, fraud, or dishonesty. Local law also provides for the appointment of either an agent or a secretary of the foundation. The agent must be licensed under the Financial and Corporate Services Providers Act, or may be a licensed trust company. As with the Jersey Foundation Guardian, this means an agent will be a person with the relevant experience and knowledge. If a person ceases to act as agent, any liability incurred whilst acting as agent will remain enforceable against him by the Foundation, although pursuant to Section 12 of the local law, an agent can be excluded from all liability except fraud. Under the Bahamian Act, unlike the Jersey Act, the appointment of a council is optional. However, if no officers have been appointed, the Charter must provide for the appointment of a council. The council has the power to access the books, records, and accounts of the Foundation. Section 15 of the Act sets out the council's other rights, which include the right to attend and be heard but not vote at meetings. The validity of an act done by the Foundation cannot be challenged on the grounds that it is not authorised by the Charter, but a member of the Council, beneficiary, or governing body can bring proceedings to prevent acts which are not authorised by the Charter. The local law provides for the indemnification by the Foundation of every officer, council, member, other supervisory person, and protector of the Foundation who acts honestly and in good faith against all liabilities incurred in the performance of their duties. The amount required by way of indemnification takes the form of a lien, which attaches to the Foundation's assets and takes priority over other claims of the Foundation, as set out in Section 65 of the Act.
Having looked at the background and development of foundations, we'll now focus on the challenges which can be made to foundations and the contentious issues which foundations can face. The obligations and duties owed by officers of a foundation will depend on the relevant jurisdiction and the governing law. However, one common thread between the rules governing foundations in offshore jurisdictions is that the officers of a foundation and all the members of the foundation's council or other governing body do not owe any form of fiduciary duty to the beneficiary of a foundation. As Amelia mentioned earlier, this is explicitly set out in the Jersey Foundation Law at Article 25, which states that the beneficiary is not owed by the Foundation or by a person appointed under the regulations of the Foundation a duty that is, or is analogous to a fiduciary duty. Consequently, the Foundation and its officers are not required to consider any beneficiary's interests when administering the Foundation, and a beneficiary cannot compel them to do so. We'll come on to the options for beneficiaries in just a minute. Now, the officers of foundations will, however, owe general duties to the foundation itself, in a similar vein to the way that a director owes duties to a company. These duties will be of a fiduciary nature, in the same vein as directors' duties are also fiduciary. And the Jersey case of A Limited versus B and C, which we will touch on in a moment, confirm this point. It's worth noting that as a consequence of the officer's duties to the foundation being fiduciary in nature, the foundation has additional claims open to it, which it could pursue against the officers under common law for breach of those fiduciary duties. Article 22 of the Jersey Foundation's law states that the members of the council of the foundation must conduct the foundation's affairs in accordance with its charter and its regulations and the law. The effect of these broad duties is that those administering the foundation are required to consider and comply with the foundation's charter and regulations. Therefore, the more detailed the charter and regulations, the more restricted the officers will be when administering the foundation. So if we put this in a practical context, let's take, for example, a foundation whose charter states that the purpose of the foundation is for the preservation of a family's wealth for future bloodline generations. Now, in such a scenario, the officers of the foundation could not use the foundation's assets to fund an extravagant car purchase for the husband of one of the family's granddaughters, because such a purchase would not comply with the wealth preservation purpose, and he would not be a bloodline descendant. Moreover, Article 22 of the law goes on to state that members of a foundation's council must act honestly and in good faith with a view to the best interests of the foundation, and they must exercise the care, diligence and skill that reasonably prudent persons would exercise in comparable circumstances. And this is a similar duty to that which is actually owed by trustees to a beneficiary under the Trustee Act 2002 in England and Wales. Similarly, the Bahamian Foundation Law, at Section 11, states that an officer of a foundation there shall exercise reasonable care and skill in the conduct of the affairs of the foundation, including exercising due skill and care in the management and investment of the foundation's assets. The effect of these provisions is that nothing in the charter, regulations, or any contract may release a person appointed under the foundation from any liability for that person's fraud, willful misconduct, or gross negligence.
In the event that the officers of the foundation do not conduct themselves in accordance with these general duties, a party with standing may apply to the court to seek an appropriate order against the officers. We have been through who has standing under Jersey law, but by way of reminder, these are set out on the slide. You will see that this is a wide group and essentially means that the actions of the officers can be policed by a number of different people. The limitation periods for claims of a breach of duty against the persons appointed to the foundation will of course vary depending on the relevant jurisdiction and its governing law. However, by way of guidance, in Jersey, Article 51 states that the period within which an action founded on a breach of duty may be brought is 3 years from the time when the person bringing the action became aware of the breach, or the period is 18 years from the date of the breach, being whichever period first expires. Interestingly, the 3-year period is equivalent to the period for bringing a breach of trust claim by a beneficiary against the trustees, rather than the period for bringing a claim for a breach of fiduciary duty against the director, which is a 10-year period. The long stop date of 18 years is not a time period prescribed by any other law, so it's a new long stop period. It should be noted that the limitation period is different where someone ceases to hold office or in the case of fraud.
Whilst the beneficiary can bring a claim against the officers of the foundation if they have breached their general duty to act in the best interests of the foundation, what options are open to a beneficiary to compel the officers of the foundation to act in a manner that benefits the beneficiary personally rather than the foundation? As mentioned previously, the officers of a foundation are not obliged to act in the best interests of the beneficiary. No fiduciary duties are owed to any beneficiary. However, under the Jersey law, Article 25(2), where a beneficiary is to receive a particular benefit from the foundation, the beneficiary may make an application to the Royal Court for an order compelling the foundation to provide the benefit in question. In such a scenario, the beneficiary must seek the order within the period of 3 years from the time when the beneficiary became aware of his or her entitlement to that benefit. Now, by way of practical example, if one of the purposes of a foundation is to fund the purchase of a first residential property for the founder's child, in the event that the foundation is not forthcoming in financing such a purchase, the relevant beneficiary could make an application to the Jersey court seeking an order that the foundation be compelled to do so. Now, as regards a claim by a beneficiary for information concerning the foundation, a foundation is not required to provide any person, including a beneficiary, with any information concerning the foundation, except as required by the constitution of the foundation law itself, or by order of the Jersey court. However, the council of a foundation can be required to account to the foundation's guardian for the way in which the council has administered the foundation's assets and acted to further the foundation's objects. Now, the position as regards access to foundation's documents under Guernsey law is rather unique. Here, local law provides for enfranchised and disenfranchised beneficiaries. An enfranchised beneficiary is entitled to a copy of the constitution, records and accounts of the foundation, and it can also apply to change the purpose or to revoke or to dissolve the foundation. Subject to the terms of the constitution, disenfranchised beneficiaries are not entitled to any such information. Now, this novel feature, which is not found in any other jurisdiction, may be attractive for those families who wish to, for example, protect their younger generations from the potentially corrosive effects of the knowledge of substantial wealth. Once the reason for a disenfranchised beneficiary's classification fall away, for example, the beneficiary has attained 18 years old, then the Constitution may permit a disenfranchised beneficiary to become an enfranchised beneficiary and thereby obtain information. One assumes the beneficiary could also become disenfranchised depending on the terms of the Constitution, so for example, upon a divorce.
As with trust, one of the claims which a foundation is susceptible to is a claim by a third party to certain of its assets. While there is no concept of beneficial ownership as a foundation owns its assets absolutely, we still see claims by third parties seeking that certain assets be legally transferred to them on the basis that assets have wrongly been transferred to the foundation in the first place. Often these cases involve claims that assets have been transferred to a foundation in an attempt to place them outside of the reach of a third party, and claimants are looking to the court to pierce the corporate veil of the foundation. As I'm sure you know, this is traditionally a process where a court looks behind the legal entity and assesses the actions and behaviour of the officers of the entity. This is exactly what was sought in the Jersey case of Delmont Limited and Senator Ross and others in 2012. In this case, Mr. Senator Ross failed to comply with personal sureties on commercial loans made in Russia. The plaintiff, the assignee of the debt, consequently obtained judgments against him for $44 million in Russia in 2010. Meanwhile, Mr. Senator restructured his personal portfolio of commercial property assets, placing them into a structure headed by Jersey Foundation. The plaintiff consequently commenced proceedings in Jersey in an attempt to enforce its judgment against the assets which had been placed within the structure. The plaintiff essentially asked the court to consider whether it was possible for the plaintiff to enforce its judgment against assets within the structure when Mr. Senator's position was that he held no interest in the assets by virtue of the Foundation's Jersey Law 2009. One of the legal arguments put forward by the plaintiff was that a claim for the corporate veil of the Foundation should be pierced on the basis that the Foundation was established in fraud on Mr. Senator's creditors, and that the court should essentially unravel the structure as that was the just outcome. Unfortunately, the case settled before trial. The court did not have the opportunity to determine the interesting questions posed. However, it remains a useful case to illustrate the fact that foundations can face challenges in circumstances where the intentions behind the establishment of the foundation may be questionable. Also, the then Deputy Bailiff did express concerns regarding the foundation regime in certain interim judgments handed down prior to the settlement of the case. The court was particularly concerned by the fact that the qualified member of the foundation had very little information about the companies within the structure, and it was reliant on its fellow council members to provide it with information, which they were unwilling to do. The effect of this was that the qualified member was operating in the dark. This was a real concern for the Deputy Bailiff, who urged the legislator to review the statute in this regard. The case serves as a reminder to those who may act as officers that they should conduct proper due diligence before accepting any such position.
The law surrounding the insolvency of trusts is generally a rather unknown area, as there have been very few cases regarding insolvent trusts coming before the court, and there's generally no legislation regarding the process of winding up a trust. Conversely, the position in relation to foundations is much clearer, with legislation addressing the issue of insolvency often being in place. For example, in Jersey, there is the Foundations Winding Up Jersey Regulations 2009. This Act provides for the dissolution of foundations and includes provisions regarding the winding up of both solvent and insolvent foundations. The law is similar to the winding up provisions relating to companies. In short, the law provides for the appointment of a liquidator who is responsible for the collecting and distributing of the foundation's assets. The liquidator is obligated to prepare an account of the winding up of the foundation and then call a meeting of the creditors at which the dissolution of the foundation will be voted on. The liquidator also has powers to investigate transactions at an undervalue and the giving of any preferences. The Act also gives the liquidator powers to make an application to the Royal Court for an order that a member of the Foundation's council be found personally liable for any or all of the debt if they knew that the Foundation was insolvent or they were reckless of that fact and did not take the appropriate steps. If it appears that the Foundation carried on activity with the intent of defrauding the creditors of the Foundation or for some other fraudulent purpose, the liquidator may also make an application to the Royal Court seeking that those liable contribute to the Foundation's assets. The Act also enables a liquidator to make an application seeking to set aside or vary the terms of an extortionate credit transaction. A transaction is deemed to be extortionate if, having regard to the risk accepted by the persons providing the credit, terms of it are or were such as to require grossly exorbitant payments to be made in respect of the provision of the credit, or is otherwise grossly contravenes the ordinary principles of fair dealing. The transaction must also have been entered into at some point during the preceding 3 years. A liquidator may also seek an order that property be delivered or seized if it appears that the Foundation is entitled to such property. All costs, charges and expenses properly incurred in the winding up of the Foundation, including the remuneration of its liquidator, are payable out of the Foundation's assets in priority to all other claims. Now, to date, there have been no cases before the Jersey Court in relation to the insolvency legislation. Conversely, an interesting case came before the High Court in the Isle of Man last year, in which the court was required to consider an application to have a foundation wound up in quite different circumstances to the normal situation, whereby a foundation is insolvent or the council simply wishes to bring the lifetime of the foundation to its close. It was a case of Cavendish Trust Company Limited versus Shared Success Foundation. Now, in this case, the applicant, which was Cavendish, was the registered agent of the Shared Success Foundation. Following a breakdown in the relationship, Cavendish gave notice of its intention to resign from its role of registered agent. However, in accordance with Section 28(2) of the Foundations Act 2011 in the Isle of Man, a foundation is obliged to have a registered agent. In this case, the foundation refused to appoint a replacement, essentially forcing Cavendish to remain in place. Cavendish consequently applied for a winding up order on the just and equitable grounds, which was granted by the Isle of Man's Chief Justice, Mr. Doyle. A winding up can be brought in Jersey on the basis that it is also just and equitable, so it will be interesting to see whether similar cases are heard in Jersey, and in fact indeed in other jurisdictions, where the registered agents and or council members of foundations wish to resign, but are unable to do so due to statutory requirements.
You will no doubt be familiar with better applications in a trust context, namely where a trustee makes an application to obtain court approval for steps taken or to be taken in relation to litigation to ensure that the trustee secure cost protection. But what is the position for foundations? In the first case of its kind in any common law jurisdiction where foundations have been introduced, in the 2013 case of A Limited versus B, C Limited, D and E, the Royal Court of Jersey considered an application for direction by a council member for guidance as to how it should act in relation to the affairs of the foundation. In this case, the qualified member of the council of the Jersey Foundation, A Limited, applied to the court for directions in relation to a claim by a third party against the foundation. The background to the case, hopefully you can follow on the slide, is as follows. A Jersey Foundation was established with the object of administering and applying its assets for the benefit of B, an individual. The foundation owns an entity, K Limited, which has acquired assets from the foundation, with the foundation having previously acquired those assets from L Limited. N Limited, which was wholly owned by a Russian bank, brought proceedings in Jersey against the foundation beneficiary B, the foundation, K Limited, the entity wholly owned by the foundation, and L Limited. N Limited had obtained judgment against B in Russia for over $44 million in relation to an unpaid loan. N Limited alleged that prior to obtaining judgment in Russia, B had orchestrated a reorganisation of assets, whereby the assets were transferred from L Limited to the foundation and ultimately onto K Limited in an attempt to shield them from enforcement by N Limited. N Limited sought to enforce its judgment in Jersey against the assets of the foundation. It was not alleged that the foundation had failed to perform any duties under its charters or regulations, and no allegations of personal wrongdoing were made against the foundation, its council members, or the guardian. None of the council members had detailed knowledge of the background to the donation of the underlying assets to the foundation, nor, therefore, the merits of N Limited's claim. Initially, B, the foundation, and K Limited actively defended the claim. However, the foundation had insufficient liquid assets to continue to do so. Consequently, under Article 46 of the Jersey Act, the qualified member of the council, A Limited, applied to the court for directions that the foundation should adopt a neutral stance in the proceedings. The other council members made no comment on the application and were merely content to support it. They did not appear or submit to the court's jurisdiction. The court held that it would be appropriate for the foundation to adopt a neutral role in the proceedings going forward on the basis that 1. The foundation holding the underlying assets through K Limited had no detailed knowledge of the background to their donation to the foundation, or therefore the merits of N Limited's claim. 2. That the claim did not appear to involve any allegation of personal wrongdoing on the part of the foundation, its council member or guardian, or to establish any personal liability on their part, except to make the foundation subject to orders of the court as to the state of the underlying assets. 3. That the foundation had no liquid funds to finance the conduct of an act of defence. And 4. That B was a co-defendant and well able, in fact better able than the foundation or its members, to defend the proceedings. Importantly, the court commented that council members owed fiduciary duties and duties of care and skill to the foundation, and they were therefore liable to be sued by the foundation for breach of those duties. The court held that its jurisdiction under Article 46 had been properly evoked by A Limited, the qualified member of the council. The court considered it had an important supervisory jurisdiction in relation to foundations that was similar to the court's general supervisory jurisdiction in relation to trusts. This case demonstrates again that the Jersey Court is happy to clarify the law in unknown areas and is creating the law in relation to foundations to be more akin to trusts and companies. There will in the future be several interesting talking points, including whether one will see more foundations seeking directions on a better type application, where there is a need to start proceedings. Only time will tell.
That brings us to the end of the substantive section of our presentation, which we hope you found useful. We do have a little bit of time to deal with a couple of questions that we've received in, so I'll just read a couple of those out. The first one we've had is as follows. Somebody's asked whether a member of the council of a foundation would be personally liable if a claim is brought against the foundation. I think the answer to this depends on both the jurisdiction and the governing documents. In Jersey, for example, the personal liability of the council members can be expressly limited by the governing documents, but there can be no exoneration for fraud, willful misconduct, or gross negligence. So personal liability will remain in those circumstances. So I think it very much depends on the type of claim being brought, and as I said, the jurisdiction and the governing documents. The second question that we've had in is whether, in our experience, we are seeing an increase in the appetite for foundations amongst our clients. It's quite an interesting question, and I think it's fair to say that foundations are clearly certainly proving more popular now than they were, say, 5 years ago. I think we would expect to see their popularity steadily increase over the coming years as clients become a bit more comfortable with the concept. That being said, at the moment, trust structures remain the general preference for our clients when they're looking to preserve their wealth. But we'll definitely see how it develops in the coming years. Third question we've had in is as follows. In our experience, is it preferable to have broad documentation governing a foundation or more detailed articles? So Amelia, do you want to take this one?
Yeah, I think the content of the documents governing any foundation will obviously be quite dependent on the client's specific situation, but from a litigator's perspective, I think it's helpful to provide as detailed the charter and bylaws as possible, which should foresee and deal with any possible future problems as much as possible.
Great, thanks. I think, unfortunately, that is all the time we have this afternoon, but hopefully, as I said, the webinar has been helpful. We will follow up on those questions which we've not had a chance to answer by email, and we'll also send out the slides from this presentation together with a recording of the webinar itself, should you wish to share it with your colleagues. So thank you very much.